everyone. A very good afternoon to everyone here. And this is Priyal Bhatia, Chief Community Officer for DPO Club. And it is our absolute pleasure to have you all join us back for the webinar series by DPO Club. Today's webinar is on a very, very interesting topic. And in lieu of, 15th of August, which is our Independence Day, we specially curated something of this sort. Today's topic is digital sovereignty and consent, preparing India's privacy compliance. As India moves towards its compliance journey, the questions are becoming more and more loud that who will control our data? Where is it going to reside? And who exactly is going to look into the consent work for India's evolving digital landscape? So, to cover these questions and throw some clarity today, we have an expert panel. This panel will be moderated by Colonel Binoj Koshy, who was a chairman to DPO Club India. And we have Rakesh Maheshwari, who has been an ex-director, senior director
Hello.
in GC at MeitY. So it's a pleasure to welcome you both today for this discussion.
Yeah,
Without, I think, any further ado, I would hand over the floor to Colonel Koshy to set the context. And we would want this webinar to be as interactive as possible to all the audience here who have joined us. Please feel free to post your question in the chat, and we will make sure to cover and answer all the questions that are there. Over to you, Colonel Koshy.
yeah. Thank you very much, Priyal, for those wonderful introduction for us. We are joined by none other than Rakesh Maheshwari, sir, one of my mentors here. And of course, when I was in the UIDI, I did report to Maheshwari sir for many others. He's a person with about over 3 decades of experience in the Ministry of IT. Frankly speaking, he has seen the largest journey from the IT Act to the DPDP law in the Ministry of IT. Now he sits on the other side of the fence. So we have the liberty to actually call him over for this webinar. Thank you, sir. Thank you for consenting to be here with
Thank you,
us.
sir.
So you're aware of the very fact that how this bill has been rolled out from the Justice Shah Committee, to what we see the act today. So, by virtue of we sitting in the month of our independence, it is it's a great privilege to actually speak to you on the aspect of sovereignty, and it is no better individual who can actually answer our queries which the industry have. And we, as part of the DPO Club, have been very advantageous in having one of our advisors as Maheshwari sir, and also for the fact that whenever we move around in India addressing, there's a large amount of questions that are directed towards this very title that we are today going to address. So, to set the stage for our audience, digital sovereignty has been discussed more in a more nationalism format, and it has been discussed in microeconomics and geopolitical terms. But the DPDP law is very, very close to the aspect of digital sovereignty. It has made this word move from the conventional form to actually the corporate boardroom. So, from your perspective, having watched the rollout unfold from the inside, and now you are sitting on the other side of the fence, what was the core philosophy behind India's shifting privacy framework to a consent first architecture? And how does this law fundamentally redefine the relationship between Indian citizen? And that's why it is called the data principle, and of course, the corporate world, sir.
Yeah. So first of all, thank you very much for having me here as part of the DPO club and sharing my experiences. And I'm sure together with you, hopefully we should be able to respond to whatever questions that you and the audience will have for me and for us. Having said so, as we know, privacy is a fundamental right, as enshrined in our constitution and conveyed by the Honorable Supreme Court. Ideally, when we look at maybe the acts of such nature across the globe, definitely consent makes one of the first principle of empowering the citizen of the respective countries. because of the privacy rights that they have got. Same is true in the case of India as well. However, while most of these countries have talked about citizen being the data subject, this is the fundamental change that we brought in was that we call them as data principal, in a way communicating that they are the owners of the data. They have in a way leased their data with informed choice, with a clear, I'll say all the principles that have been talked about of granularity, of being informed of the purpose, and maybe in what way can the citizen exercise their rights. All those things, in a way, we have empowered the citizen to be called as data principal, simultaneously conveying that the organizations who are doing business around it are actually running it as a custodian and not the owner, and hence it is their responsibility to see that the data is used the way they have been authorized to use, and to the extent they have been authorized to. Second point which I wanted to convey was that, like the previous IT Act, this law is also extraterritorial. And to that an extent, anyone who wants to do business in India, from within India, from outside India, has to follow the law. And particularly those of such organizations who are significantly large will also have to have a resident data protection officer. And to that an extent, they clearly commit to follow what the Indian DPDP law of, in fact, mandates them to do. And of course, all the other aspects have already been stated in the Act, but this is how we are, in a way, empowering the citizen, and we are obligating the organizations, including all the organizations across, whoever is wanting to provide services here in India.
Yeah, thank you, sir. So my next question is
Yeah.
a little related to the fiduciary aspect. I
Mhm.
know you are also been going around the market and speaking to many people. Uh, as far as DPO Club is concerned, when we interact with the public, the corporate, the enterprises, the houses that are implementing, we see a lot of inhibition with respect to this law. The first aspect is that the biggies or the market enterprises who are big enough are able to absorb the, because there's a cost attached to any of this implementation. But however, the smaller enterprises do have a little bit of inhibition. Most of them say, "Let's see how the water flows, and then we will, try and swim in it." So, from your perspective, sir, and with your experience, can you tell us two myths, misconceptions that this law has made to the industry? Secondly, sir, from a standpoint of, as the time is running down now, and we know that the consent management framework has to be in place by, say, November, and the bill is to be effective by May.
Mm.
What is that zero compliance priority that you would suggest for the market, sir?
Okay. So maybe I start with the myths first, and particularly the larger organizations. They do believe, for example, that they already are in compliance with many of the international standard acts, laws, particularly the GDPR, because that's something, I mean, which is being called as the mother of, in a way, all privacy laws. While definitely it helps them to comply with with GDPR compliance or with any other international law compliance, because the philosophy of most of these laws are more or less on a similar line. But still, there is a difference in terms of what each of them expects. And if I look at the Indian context, the basis of data collection is only practically only the consent. Vis-a-vis, if I look at the other laws, which is where consent as well as maybe some legitimate business cases have also been talked about. The law clearly spells out also the requirement of 22 languages, and hence maybe customization to Indian context. Customization to Indian context is also very, very important. The third aspect is with respect to the consent, the DPO, I mean, wherever applicable, particularly once again in respect to the larger organization, that maybe it is once again that they will have to have a resident, India resident DPO to be there. And if we read it through the rules, then maybe some independent audits happening and maybe sharing of report to the data protection board. So to that an extent, first of all, the myth that if we are compliant with one law, we will be compliant with DPDP Act also may not be may not be true, fully true, definitely. The second is maybe particularly in respect of Indian companies that maybe that this act requires data localization. Yes, it does require data localization, particularly in respect of the security logs. But beyond that, this law is very pragmatic in nature and per se permits data being shared to any other country if it has not been blacklisted. And as of today, there is nothing which has been blacklisted, as long as the controls are in place, as long as data fiduciary, data processor, and your ability as data fiduciary to be able to manage what data processor is doing, as long as that is being ensured, maybe the things are done. So that's yet another myth which is there. And particularly the smaller companies, they believe, and as you have rightly stated, that maybe let's see, I mean, which way the water flows, and we will accordingly adjust ourselves. And to them it appears like any many other management system standards, particularly, that maybe by virtue of policies, by virtue of putting the privacy policies and other fine tuning such other aspects, maybe the terms and conditions which they are offering had been offering as part of the IT Act, mm, whatever privacy policies were being offered, maybe that is how they will be able to manage, or maybe India mein sab chalta hai. That's the kind of scenario. And lastly, I want to also convey that there is a bit of confusion in respect of what a consent management is versus what a consent manager is. So maybe on this last part I'll take up sometime later if the need be. But there is a bit of confusion, and people believe, I mean, that they will have to have a consent manager, all of them. So this is yet another I'll say gray area. And then coming to your second part, as to finally, we it's almost, I mean, 15th of August. So we are left with how many months? Maybe 8 months, 9 months. The 0 day is approaching fast. As I said, it's not about writing policies, fine tuning policies. There is lot to be done. And when it is a law, it's not a voluntary standard. It's a law which has to be followed in full. Non-compliance at any point, and particularly for those who for whom the data principle exercises their rights, or when a breach happens, they are supposed to report this breach to the data protection board starting from day 0. I therefore will expect at least those companies who have not started, that they should start discovering the means and ways of how personal data is being collected, how much personal data do they have, particularly, and they also need to have on 0 day a sort of a grievance mechanism also being put in place, at least from a contact perspective, where if the user makes a request as to what data do you have with respect to me, or maybe if I put a erasure request, the organization must know as to what data do they have with respect to the data principal that's putting the query. That's very much essential. But simultaneously, coming from the security perspective, I also believe in the initial days, because you have to exhaust your grievance redressal mechanism for which the organization gets 90 days. So I believe on day zero, nobody will be able to reach out to the board, because the board will say, finish your options first, and that company is actually having 19 days 90 days to, or maybe bit more if somebody puts an interim response. Therefore, what will happen is that in the beginning, it will be mostly data breaches which shall be reported to the board. And hence, as an organization, you should be ready to know if and how you will be handling such data breaches as well. So, in a way, ideally, as much as possible, try to have a governance structure in place, try to have as much data, I mean, at least data discovery and the way it has been collected. But definitely, if you are collecting, maybe if you are buying data, I'm talking in respect of data fiduciaries. If you are buying data for which there is no logical connection of how have you got, and when the data is being collected practically without consent, that must stop.
Right.
So you have to find your own means and ways of how you should be collecting. So those are some of the, I'll say, recommendations from my perspective for those who have still not implemented and want to implement in sincere.
So my next question is something that probably you have faced in your service in the Ministry of IT.
Mhm.
Generally, when we this is with regard to Section 17 provisions of the Act of
Okay.
Exemption, Chapter 4. Now, sir, while you had served for so many more years in the government, you would have encountered issues like there is a law to be provided, but at one end you would be looking at how to empower the citizens also. So there would be a very what shall I say, a very sensitive balance that you would be doing, as you know, you're part of the government but yet you represent a citizen, that's all. So, and India's sovereignty is nothing but a two-way highway, sir, that we are all aware of. So when it comes to exemptions, we see that the state has got larger provisions of exemption, whereas the customer or the citizens have very little say when the exemptions is invoked, and so there is a consent revocation that is impossible for a person. So in that type of conflict, how will the DPDP law play, and how do you, and what promise you have for the citizens in this provision, sir? Because I know I'm asking this as on behalf
Yeah.
of a citizen, but you
So
are a government of India.
yeah, yeah.
Yeah,
So first of all, let's understand that there are genuine needs of the government to be able to process our data, particularly, or maybe deny or be outside the scope of this act in a limited way, or maybe in a completely exempted manner, as has been provided for in 17 to 17 2A, hopefully. So so one, this was always the most contentious section when, particularly when the 2019 bill was presented, section 35, I believe that was it. And the JPC had lots of discussion around this section as to what kind of checks and balances should be put in place, particularly for such organizations who are to be made completely exempt. So criteria should be very well defined. Notification must convey as to what checks and balances such organizations will have. In my own perception, in my own view, The way the present act has come, those checks and balances, that criteria has been spelled out, but checks and balances have not been spelled out. Having said so, what will be those checks and balances? First of all, of course, those notifications have not really happened in respect of those organizations which are going to be the complete exempt, but the criteria has been given. But beyond that, the Supreme Court has already held that privacy is a fundamental right, and the way this aspect of, I mean, the success criteria of the law being the constitution being upheld, so those aspects of legality, proportionality, and necessity have already been spelled out. So if there is at all, I mean, in future going to be a bit of misuse, maybe there are constitutional safeguards available, and hence I believe over a period of time this maturity should come. Now, coming to the citizen empowerment, there is another side of the government which for the authority, for the law that they have, for the law under which they function, for the policies under which they function, for the authorization, licensing, and other things that they do, for the law enforcement to be able to get the data. But once again, there are legal provisions. So bit of exemptions have already been provided to some so legitimate, what we say, I mean, legitimate uses. Section 7 already talks about it. But for all such organizations which are exist in a way exempt from collecting the consent formally, but are not exempt under 17.2, will have to have maybe lots of, I'll say, checks and balances put in place, and they need to prove that they are also complying to the law, and in case any breach happens, they're also in a way mandated, except those who are covered in the 17.1, particularly B and C, law enforcement agencies and maybe courts. So most of them, for that reason, are obligated to even report it to the data protection board, and hence prove that they have done it. They have collected data based on whatever functions, legally authorized functions, that they are supposed to do, maintain security, report breach, and therefore have all the mechanisms as is required for any body corporate as well.
Thank you, sir.
Coming,
Thank you.
yeah,
Yeah.
I come to the citizen empowerment. I come to the citizen empowerment. I believe that was also the question.
Yeah.
So on that front, in any case, the citizens should be able to reach out. I agree that maybe they do not finally, when a citizen loses, or the breach happens in respect of naturally citizens' data only, and when the citizen approaches the board, the gainer is actually government. The citizen, the data principal per se does not get anything unless the person goes to the court and asks for compensation under the torts law. So maybe that's something which over a period of time, hopefully, as the things evolve, we will have to see as to what way ideally, for a compensation for a loss that the person has suffered, as to what way it can be made. But beyond that, erasure, of course, you can always ask, but any erasure will always be along with, to be read along with other laws. Maybe I can explain if required.
Thank you very much, sir, for that perspective. So, one thing we take assurance as citizens is that there would not be a blanket sanction of exemption. There will be certain amount of justification, and the Data Protection Board will have an oversight over it. So, coming to a very popular question in the market, generally when we go, there's a lot of inhibitions around Section 10. Who will be a significant data producer? What will be the criteria? Of course, those 6 points which are written: volume, sensitivity, national, sovereignty, public order, things like that. It's quite literature in terms of what is there. Now, there are two ways how the board or the Ministry of IT will classify these fiduciaries. Probably one could be based on the volume, and that is the talk of the town. They say 1 lakh customer hai, तो probably we'll all become significant data fiduciaries. 1 lakh से ज़्यादा है. But then there is also a factor in which sector wise risk model can also be in place. So being the designer of, I mean, I won't say literally the designer, but we were there when the bill was actually being drafted and when it came out. So what do you think would be the, how do, okay, let me put it the other way, sir. Do you think the corporates will have a leeway to decide, number one? Secondly, do you think there will be a judicious form of deciding who the significant data fiduciaries will be?
Yeah. So, so first of all, of course, the principle of proportionality always applies. Having said so, legally, it is the government's responsibility to come up with notification of which entities or classes of entities shall qualify as significant data fiduciaries. Unless I am formally labeled as a data significant data fiduciaries, the obligations as have been casted in section 10 cannot be applied. So that's number one. Number two, however, whether you are a significant data fiduciary or not, you need to comply with the provisions of the act. Forget about section 10 for the time being. Rest all the provisions of a valid consent and all those informed consent and all aspects of consents, all aspects of reporting to the debtors, to the citizen, grievance redressal, reporting of breach, timely reporting of breach, doing forensics, and all those things are important. Now, let's look at the banks, the airlines, the PSUs which are dealing with, say, let's say, LPG distribution, electricity distribution, railways, IRCTC, maybe payment gateways, maybe social media platforms, which whether you call it formally SDF or not, they have crores and crores of data sets, personal data sets with them. Coming to maybe a bit of sector, one more sector which I missed was in respect of hospitals. So even if you are a 500 plus bed kind of in a hospital, I'm not saying that it will become an SDF, but if you are, let's say 500 bed kind of in a hospital, I'm sure per day patient OPD will be around 1000 per day. Maybe, of course, IPD it will be around 500 bed hospital, so around 500. And put together, if you see, maybe this kind of an hospital will have about 1 crore kind of personal data sets which are health oriented, which are sensitive, financial also, which will be sensitive, though no classification has been done, but the fact also remains that the amount of injury, the damage to the reputation of the organization, damage to the individual concerned will always be much higher, and therefore it is always a safe bet for an organization to consider, if they have the resources available with them, that they are a significant data fiduciary. So 1 lakh, I'll say it's much lesser in terms of benchmarks. But if it is a strategic data, if it's a biometric data, maybe 1 lakh can also be one such category. But beyond that, at least the examples which I took can safely assume without a notification that they are going to be SDF. What it means to them is that they must at least start working towards having a data protection officer, a dedicated data protection officer. Beyond that, maybe an independent audit. Who will carry out the audit? Maybe as of today, it has not been defined. So anybody, I mean, who you think is independent audit. You have to carry out DPIA, maybe not in a formal way. You have to do otherwise also in a qualitative or quantitative way. That will be the difference once you are declared as a SDF. But either way, the principle of deciding as to or prioritizing as to what maybe needs to be done, where exactly tools need to be applied, what PETs need to be brought in, is highly dependent on the kind of activities that you are involved in, the kind of risk that you face, and maybe your own past history of kind of incidents that you have suffered with. So 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 don't wait for SDF. Ideally, I would love SDF to be notified, and it's not the board's responsibility, it's the government's responsibility. But don't wait for SDF. The good thing will be, if you are not declared formally as SDF, you don't have to follow whatever the committee may be constituted, and data localization and those aspects. You don't have to till such time you are formally declared.
Thank you very much, Maheshwari sir, and it's nice to hear from the horse's mouth itself on aspects of
So
such.
I'm outside the cart now. No more a horse.
Yeah, I agree. So one more sensitive aspect, I'll give you a use case here, is the right to erasure under that section 12.3 provisions. Now, when I was speaking to a few people, one of the most important aspect is how to decide when to erase, or if an erasure request has to be erased at all. For example, sir, let's say I'm running a loaning agency. I'm a bank, or I provide loan. The aspect of an application coming to me and the very fact that I rejected a loan also is a database that I need to keep for lifetime till the time, because the person may apply again. So the reasons for rejection on the first instance need to be stored. So when we talk of erasures, in fact, if you frankly ask me, the Aadhaar also does a one is to many check before a number is generated, a 12-digit number Aadhaar is generated. So we do not intend to actually delete dead man data, because uh, you know the nuances to it. So in terms of deletion, there are sectorial requirements like the RBI, the PMLA, and all that, which have given out periods. But insofar as many government establishments or many regulators are concerned, there is no timeline fixed for retention. How do we honor this right of erasure of a principal, sir?
Yeah. So one clear principle which has already been laid in this law, that this right to retention should be as minimum as possible.
Okay.
So that's the governing principle on which anybody has to develop their policies. Simultaneously, look into the sectoral requirement. If RBI says that this data has to be kept for 7 years, you have to keep it for 7 years. If certain says you have to keep the logs for 6 months, anyway, the privacy rules itself say that the security logs need to be kept, particularly which can prove violations, for 1 year. So they have to be kept now for 1 year. The intermediary guidelines, IT rules, mentioned that an account which has been created by a person, if the person decides to close the account, or if the platform decides to close the account for whatever reason, 6 months is the time they have to keep this record on. And the purposes were very clear, that maybe in between, if the law enforcement body has to come and a account was being misused, there should be some trail available. 6 months was set up as the period. Similarly, for e-commerce and for large, I'll say, social media platforms, once again, certain retention period, particularly when the account becomes inactive, has been stated. So as long as the account remains active, in any case, the record shall be kept. You were taking the example of loan. So as long as loan repayment is being done even if it is being done over a period of more than 7 years, the account will continue to remain active. The account has to made inactive and maybe data erased 7 years after closure, 7 years after the decision, let's say, of the rejection was taken. And I will request, sir, I mean, particularly the example that you gave, don't keep the history beyond a particular point. The person's fortunes do change, and therefore 7 year itself is a reasonably good period for any processing that has happened in respect of that particular person in the past. Don't beyond this point carry it in future. And the principle of data minimization has to be kept in mind. So it will always be intersection of this law's intent versus the sectoral law, and wherever such there is no other law available, a common sense approach has to be applied. In respect of Aadhaar, the act itself says that your data shall not be deleted because they have a different purpose.
Right.
है ना? So it may, you may not be able to use Aadhaar, but Aadhaar, I mean, your biometrics will remain, and that's by
Correct.
law. So if the law has already put it has to be kept, it has to be kept.
Yes. So, I know I can keep speaking to you by virtue of your knowledge base that you carry. But I have one last question, sir, which is a very sensitive. I want to address that segment. The children, sir, Section 10 provisions, which we are talking about, is the verifiable parental consent aspect. There are a large number of inhibitions, especially with banks, which have proliferated, child accounts without even having that verifiable parental consent. I'm just talking about one sector. There are many
Yeah,
sectors where there is the problem of verifiable parental consent, sir. Now, though the law does talk about extending the DG locker, and in the absence of, in Haryana we have the Parivar Pehchan Patra, which got a family tree attached to each of these numbers, serial number, individual Aadhaar number or something like that, with the Haryana government. Similarly, Karnataka has also got one. Maharashtra is also coming out with something of that nature. However, in the absence of establishing the lineage in terms of succession or in terms of the child to parent relationship or parent to child relationship, how do you think the corporate should take up this challenge of verifiable parental consent, specifically with regard to age gating, number one? Number two is for the fact to establish relationship.
yeah.
Well,
That's a very tricky kind of a question. And therefore, once again, I go back to the principles. The principles of the law are clear. The child should not be made a scapegoat, should not suffer, because the child is not really able to, is not able to take, many a time the call is not able to understand the nuances, and hence child protection is of, child safety, child protection is of utmost important to the government. Targeted ads to the children should not happen. So the boundary lines have already been cleared, conveyed. Comes comes the requirements, the way they have been conveyed: verifiable parental consent, which is, I mean, at least I also, is this is one question where maybe I'll also like to have your opinion as well. But before I ask that, particularly those which are in the government sector or in the regulated sector, you took the example of certain state governments, you took the example of certain banks. So in the regulated sector, definitely they are governed by the requirements as are stated by the, by RBI, or maybe by SEBI, or maybe governments also. The norms are very very clear, the laws are very well laid down, and if there is a conflict, then of course there is a problem. Otherwise, many a time things happen actually in the physical digital world, I mean, put together. And therefore the kind of, maybe the verifiability that is being is, I mean, is required, actually can be done. The problem is, which are digital native platforms and have a rating, say for example, of apps which is less than 18, and therefore actually allow children to be onboarded onto their platforms. Many of them are completely new, may not be old, and therefore we don't expect parents to be there, or maybe the app itself has been designed particularly for children. And to that, and that's where I believe, I mean, this is a challenge as of now, and this is where I'm just putting the question back to you.
yeah.
My point is simple: the intent are there. Once
Yes.
the problem statement has been stated, people will come up with the solution. we have conflicting requirement of privacy, I mean data minimization, and definitely the government will not like uh, id cards and other things to be passed on. So how do we maintain the balance? Maybe I request you to respond further.
Thinking loud and being part along, I've worn the same boot as you in the Ministry of IT. One is the DG Locker, which exists, sir. And from 2008 onwards, if I remember, the 12th and 10th certificates have actually been populated on the DigiLocker. In fact, the child gets its result first on the DigiLocker and then the certificate comes. So the DigiLocker does have got the relationship data and of course the age, date of birth data, however authentic it may be. We're not questioning the authenticity of it. Now, the second aspect is for the government to actually expand the digital public infrastructure to enable anybody who wants to use this facility. Of course, there might be a charge or there might be some fees, but then there is a requirement of extending this digital public infrastructure to anyone and anybody who wants to use this data. Of course, like how we have the AUA, KUA ecosystem in the Aadhaar, maybe
Yeah.
something like that should be coming up. And of course, I think by virtue of your closeness to the ministry, you can take back this point and probably allow us to use this data for such, especially the age gating aspects. A child will declare that I am 18 years and above, unknowingly or knowingly. So that one aspect, which is probably one. So one very sensitive question again is actually from our daughter, and I think you are the best person to answer this. She says, "Okay, you've built a safeguard on verifiable parental consent, but what if a parent assumes that the child consents and misuse the child's data? What is the safeguard for the child from a rogue parent?"
Okay. So this is where, in any case, see why this law took time, and lot of time. You talked about Shah Committee, which was actually constituted in 2011, is precisely for this reason only, that this is not a construct which can be universal, and therefore has to be seen in a case to case basis. Ideally, I would have loved that this data protection board was given a bit more powers to be able to develop such nuances, which as a board, as a regulatory authority, you can always do it faster than the government and not get criticized. So I believe that such kind of laws will undergo amendments. Maybe it should not be, I mean, having the same kind of a fate as the IT Act has. But even in IT Act, I do believe 2008, 2017, 18, 22, 23, minor amendments actually have happened, though we have never talked about it. But I'm sure some good amendments will happen in this particular act. Say, for example, legitimate use cases, and maybe many more such cases will be there, including the one you have mentioned. The provisions are there already in the act, that maybe in some situations, up to certain period, by virtue of notification, government can allow, disallow, whatever. Beyond that, yes, as the scenarios develop, maybe the law catches them.
So you make things so interesting that we have actually overshot the time. But with your
Yeah,
permission, sir, we'll take
sorry,
some questions from the audience.
please.
Priyal, are you there? Can we have the questions populated, please? Yeah. So the first question is from Joyce. She says that my question, why by the time consent management will come in place, most AI apps have already captured PII. How do you see this being addressed in India?
So, first of all, please be see, in any case, if it is a licensed versus a freeware, which is how the difference of maybe the data which is being captured and is being used for training sets. One is about that. The second is, lots of user awareness has to happen, that particularly people, because it's not about some attributes like your name and maybe phone number, or maybe the place from which you are accessing AI tool. In any case, those basic details are captured. But beyond those basic details, it's actually in your hand to provide or not to provide your own further details, personal details. And that will happen even after 13th of May, because the consent is actually your right. If you allow any, if you share your data, it's considered as voluntary sharing, and that's why the platform are actually using. Of course, in a B2B environment, in a licensed environment, the terms and condition of how the AI tool shall be used shall prevail, and there are definitely better controls available. So, in nutshell, I'll say, as far as AI is concerned, and maybe as far as our personal usage are concerned, the law is not going to change the way the data is being collected. It's for us to see as to how much do we want to share. Okay, and that's where I maybe request Koshyji
Thank
to
you very
further.
much for that question, Joyce. But you should be well sensitive for the fact that the government is taking cognizance for this particular buffer period. To remember, there might be a notification that will come up to safeguard those crawling or those scrounging which the AI is doing by virtue of thinking that the law will come in and before that we can do all the crime activity. So don't worry. The law is in safe hands and it will come in its full thrust when the law is in full effect. Yeah. We have a question from Sabir Hassan. He says DPDP as such doesn't prevent the flow of data except to blacklisted countries. However, RBI ensures data localization. So sectorial laws will prevail over DPDP Act.
Yeah, the short answer is yes.
Yes. Yes. Yeah. Can we have the next question, Priya?
And not just with respect to the RBI. In fact, any other sectoral requirement, if it happens to be stricter, which in any case it will be, that will apply in respect of that sector's data.
Thank you, sir. Next question, Priya. Okay. We have Naresh, question from Naresh. So you mentioned about data localization requirement for traffic logs. Can you please share the legal reference for that? Because I understand only the time period is mentioned in the rule, more especially rule number 6. Yeah.
Hmm.
So,
So I will request you to maybe have a look at uh, the CERT's directions of April 28, 2022.
thank you,
And
sir.
that's where they have mentioned that the logs, security logs, should be available locally.
Yeah. Explicitly, there is no mention, but if you see the certain notifications of CERT, it does mention localization as a requirement for sensitive personal data, at least. And
So
sensitive personal
so
data was actually classified much earlier, even before the DPDP law. Yeah,
so CERT's direction in respect of localization of security logs are unambiguous and are full.
yeah,
So please have a look at the CERT's directions.
yeah, yeah. Can we populate the next question, please?
The tough one is gone. Has once again come.
Yeah. Again, it's a question from Joyce. She says, have for children on Facebook and Insta are opening without permission of parents and obligor verification or validation. So what ma'am is asking probably is, uh, presently they are all doing it. So what is the outcome of this, sir?
So once again, I mean, on the children front, frankly speaking, I am also, as I said, I mean, many times clueless. As of now, they are already taking the age in some way or other. May not be exactly the date of birth, but definitely asking as to what your age is. Less than 13, they are not allowed. because of the fact that all of them follow the COPPA of US.
Correct.
Beyond 13, as of today, yes, they are being allowed. I'm sure, I mean, by 13th of May, these platforms will also have a solution in terms of asking, I mean, as to how exactly you correlate it with the parent, and the parent has given the consent for you to be able to operate, or ideally they should be then withdrawing those accounts.
Yeah.
And beyond this point, as of today, maybe I also don't have an answer, except that further I can only say, for example, WhatsApp has very recently, that's what was there in the news, that they have started, maybe at least started asking the details. And
Sir,
those of us who declare I mean, give the wrong data, see, number one, they will not be able to complain, so they lose the right. Actually, they lose the safety provisions as will be made by the platform if they declare it wrong. The second part is, when Facebook and all such social media companies, AI companies, have so much of data about you, don't you think that they will, by virtue of the algorithms that they run, the kind of questions that you ask, will they not be able to judge your age? Yes, they will. Yes, they will be able to judge with a reasonably high accuracy. Beyond that, let's see, I mean, what way the act actually gets implemented, because implementation and enforcement is very, very important. Maybe we will have to see as to how much we are able to enforce. Law is clear.
thank you very much, sir. It was one of the most, or should I take up this next question, please? Yeah,
Sure.
Sneha has done a good. Sir, a lot of schools and colleges are unsure if they will get a notification from Ministry of Education compliance, or if they come under the ambit of the DPTP law, or are they exempted, sir?
Yeah. So first of all, schools, colleges, because they deal with children, they deal with lots of personal data. They are like any other organization, come within the ambit of DPDP Act. Whether there is a notification by Ministry of Education or not, the law applies.
Thank you, sir.
Okay.
That's a very clear cut clarifications that you have given. In any case, the Ministry of IT is more concerned for the safety of kids. So this law is, if you ask me frankly, is more directed towards safety of children rather than for the adults. I mean, not that it is not meant for the adults, but it is. Yeah. Uh, Thank you very much, Maheshwari sir. I know from your busy schedule, I have grabbed a lot of your time, and you've been explicit in answering, and you've been frank in answering. Frankly speaking, I've never seen such direct answers, from many government officials, frankly, who have been government officials at least. And we really thank you for all that clarification, sir. And I know this video will go viral in terms of people getting clarification and preparing India in this beautiful journey. And I always say that I'm very lucky to see the privacy implementation in my lifetime in India. And like how you saw the IT Act when you were probably a young director in the ministry. So thank you very much once again, sir. And we are all benefited by your presence and your answers that has been given. Thank you, sir. Thank you very
Thank
much.
you, sir, for taking it so well and maybe putting me on such a high pedestal which I don't deserve. But but together we have sailed in the same boat, so let's be in the self appreciation club as well. Good. Thank you, sir.
Thank you, sir.
Yeah.